Contract interpretation is the study of what parties intended when they made contractual obligations to each other. Today we're going to focus on interpreting whether or not a term in a contract is an express condition or a promise, and this has a huge impact on whether or not the parties have actually performed their contracts. I'm Professor Seth Orenberg. Thanks for joining me today. Let's jump in with a quick review. First off, remember that all contracts require three things: offer, acceptance, and consideration. We're going to focus today on the offer because it's in the offer that the terms of the contract are laid out. Remember that the offeror, the person who makes the offer, is the master of the bargain. It's the offer that contains all of the relevant terms. If the offeree, that is, the person who receives the offer, responds with other terms, that's not an acceptance, that's a counteroffer, and that offeree who responded with a counteroffer now becomes a new offeror, and the new terms are the terms proposed for the contract. Again, the offer contains all of the terms, and usually those terms contemplate some exchange of promises. A promise is a manifestation of an intention to act in a certain way, so made as to justify a promisee that a commitment to act in that way has been made. Let's look at that visually. On the left-hand side, you see the offeror, the promisor, the master of the bargain, who's making certain promises to the offeree, or the promisee, and seeking in return certain promises from the offeree. Both parties will have to abide by those promises. Both parties will have to perform in order for the contract to work. The promise from the offeror to the offeree is called the promise, and that return promise is what we know as consideration. Let's look at a simple hypothetical to remind us the basics of offer, acceptance, and consideration, and then we will see how conditions complicate the picture a little bit. Abby emails Brian, stating she is willing to pay him $10,000 in exchange for his Honda Civic. How does this look visually? Well, on the left we have the offeror, or the promisor, Abby, and she's making a promise. The promise is to pay $10,000. She's making that promise to Brian, who is the offeree, or the promisee, who is making an exchange promise, which is known as the consideration, of providing his Honda Civic in exchange for the $10,000. As a quick reminder, if Abby simply promised to give $10,000 to Brian and expected nothing in return, that would be a gratuitous promise, not supported by consideration. So again, we see there are two promises in Abby's offer: her promise to give Brian $10,000 and his return promise to give her his 2008 Honda Civic. Now we're going to complicate the picture by adding the concept of conditions. We saw already promises are duties under a contract. Abby made the promise to give $10,000. She has the duty to provide that money. Brian made the promise to give the car. He has that duty. Those are the duties under the contract. Conditions, however, are events, uncertain events which may or may not occur in the future, which will cause those promissory duties to become due or can extinguish promissory duties. Conditions are inherently uncertain. They are things that may or may not occur, and whether or not the parties have to perform the duties under their promises depends on whether those conditions occur or not. A visualization might help make this abstract concept a little more clear, and don't worry, we'll follow up with plenty of hypotheticals today. We have, again, our image of the offeror or promisor, Abby, in this case on the left, who's making a promise to the offeree or promisee on the right, and that promisee is going to give a return promise known as the consideration in exchange for the promise. But now we're going to insert a condition onto the promise. So Abby's obligation to pay the $10,000 will depend on whether a future uncertain event occurs. We're going to add one new fact to our fact pattern in Hypothetical 2. Abby emails Brian stating she's willing to pay him $10,000 in exchange for his 2008 Honda Civic if his car passes emissions testing. If his car passes emissions testing is reasonably interpreted as a condition. She only wants to buy the car if it in fact passes emissions testing. In other words, she's indicating that her desire to purchase the car is conditional on that car having a certain quality that is unknown at the time and may or may not occur in the future. Let's draw it out. On the left, we have Abby, our offeror or promisor, who is offering $10,000 to Brian in exchange for his 2008 Honda Civic. But now we also include a condition that the car must pass emissions testing. If the car does not pass emissions testing, Abby is not going to be obligated to pay the $10,000 to Brian. Now that we've seen a couple of very simple examples, let's characterize this with some rules that we can more generally apply in a variety of circumstances. There are two steps to analyzing conditions. The first step is to identify and determine whether a contract term is a promise or is in fact a condition. And second, the second step is to determine the effect of the conditions on the duties to perform the promises. I'm going to show you the operation of these two steps, and I'm also going to get into more detail on those rules using the Restatement of Contracts Second. The Restatement of Contracts Second, Section 224, defines a condition as an event not certain to occur, which must occur unless its non-performance is excused before performance under a contract becomes due. In the case that we just saw, Abby made it clear that she did not want to buy the car unless it passed emissions testing. Passing emissions testing is an event in the future, and it's uncertain whether the car will pass or not. And when Abby, who made the offer, stated that she would only buy the car if it passes emissions testing, she was making it clear that emissions testing was a condition that she would impose on her duty to perform the payment of the $10,000. In other words, Abby, who was the offeror, as we know, that is the master of the offer who sets the terms, she made her duty to pay $10,000 conditioned on Brian's car passing emissions testing. In this case, it's pretty clear that Abby intended the contract to include a condition on her promise to pay. Sometimes courts will have to do a little more work to interpret whether or not a term is in fact a condition. We're going to see some cases after we go through our simple hypotheticals that are a little more real-world and complex. Our second step is to look at the impact or effect of a condition being present on a duty. And now we look to Restatement Section 225. Section 225 of the Second Restatement of Contracts says, performance of a duty subject to a condition cannot become due unless the condition occurs or its non-occurrence is excused. Let's look at this example. If Brian's car fails the emissions testing, Abby does not have to buy it. In other words, because the condition failed to occur, her contractual duty to buy the car did not come due. The duty was subject to a condition. The condition did not occur, and as a result, Abby's promise to pay $10,000 never became a duty. She did not have to pay him the money and does not have to buy the car. That's all pretty simple so far, but in the real world, there's lots of ways that parties can complicate matters. Let's take a look at another hypothetical, adding a few layers of complexity to the situation. In Hypothetical 3, let's imagine that although Brian's car failed inspection, he can fix it. And in fact, he does fix it. The very next day, it only cost him $100, and he gets it back to the inspection, and it passes. Now, it failed inspection on day 1, he had it restored, and it passed inspection on day 2. Now, does Abby have to buy the car? Let's look again at the restatement for a rule, and then apply the rule to our facts. Restatement Section 225, subsection 2 specifies, unless it has been excused, the non-occurrence of a condition discharges the duty when the condition can no longer occur. And comment A clarifies that the time within which the condition can occur, in order for the performance of the duty to become due, may be fixed by a term of the agreement, or, in the absence of such a term, by one supplied by a court. Combining Restatement Section 225 sub 1 and 225 sub 2, we see that there are actually two effects that a condition can have. In the first place, the non-occurrence of a condition means the other party's duty does not come due. In the second place, we also see that at some point, that duty is discharged indefinitely and will never come due. In other words, there is a period of time where the duty is not due yet, but it could become due in the future. And then, at some point, that duty is discharged, and no longer will that promise have to be kept under any circumstances. Returning to our hypothetical for a moment, we again are asking the question whether Abby has to buy the car. Originally, she did not have to buy it because it failed inspection. But now that it has passed inspection, even though it failed the first time, does Abby now have a duty to purchase the car? Or is she excused from her performance indefinitely? In other words, has her duty been indefinitely discharged, or was it simply latent and waiting for that condition to occur? And as a reminder, the parties did not specify when this had to take place. So the court is going to need to supply that information. It will have to determine when the parties are able to make the condition happen and when it is too late, such that the duty to perform is discharged. Here, the parties did not specify a time, and the court will determine a reasonable time. What is a reasonable time? Well, it's hard to say in all cases what's reasonable, but under the simple facts as I presented them, 1 day seems like a reasonable time. Therefore, Abby will have to buy the car from Brian. The condition occurred before her duty to perform her promise was indefinitely discharged. Let's turn the hypothetical again. In Hypothetical 4, let's imagine that Brian's car wouldn't cost $100 to fix. Maybe it can't be fixed at all. Or this $10,000 car would cost $20,000 to fix. In any event, Brian doesn't get the car fixed. The car never passes inspection. Can Abby sue Brian for failing to make the car pass inspection? In other words, is Brian liable at law for his failure to make this condition occur? Again, we'll look at the restatement, and here we're on 225 sub 3. We learn in 225 sub 3 of the second restatement of contracts that the non-occurrence of a condition is not usually a breach unless the parties intended there to be a duty that the condition occur. We have a case for this, and that is Morrison v. Baer. You may remember it as the case where we had a failure to repair a cracked heat exchanger. Morrison purchased houses, refurbished them, and rented them to college students, and Baer was selling a house. Morrison and Baer entered into a contract that had a special condition saying that Morrison would buy the house from Baer subject to a special condition that Baer produce a receipt showing a heat exchanger that was cracked was indeed fixed before the closing of the sale. Setting aside a kind of too clever by half hokey trick by Baer, who produced a receipt that showed the heat exchanger was not fixed, the parties clearly intended that this heat exchanger was to be fixed before the sale was to go forward. Heat exchangers are expensive, and this made a material impact on the cost of the house and the value of the house. Morrison wanted to force Baer to sell the house to him for a lower price because he failed to fix the heat exchanger, whereas Baer said that, well, first off, he provided a receipt, but that argument did not hold water. He didn't actually fulfill what the parties intended. And moreover, he said that he had no duty to fix the heat exchanger. It was a condition, and when it didn't occur, Morrison did not have to buy the house, but did not have the option to buy it for less. Who won in this case? Well, Baer did. This was a condition. It was very clearly a condition. It was in the section of the contract called Special Conditions. It's the sort of term we'd expect to be a condition. And as a result, it was treated as a condition. When the heat exchanger wasn't fixed, This meant that an uncertain event in the future did not occur, and as a result, a duty to perform a promise did not come due. Morrison's duty to buy the house from Baer did not come due. In other words, Baer did not breach the contract. Morrison simply had the option of not purchasing the house because he no longer had a duty to do so. This is not always the case. Sometimes a condition is also a promise, and these are called promissory conditions. When a party does have a duty to perform a condition, it's called a promissory condition, and the case for this is International Rotterdam. In this case, the parties agreed to buy and to sell some quantity of rice. There was a condition to the purchase of rice that the buyer specified the delivery address and the quantity of rice they wanted by December 17th. The buyer failed to do this, and the shipper never shipped the rice. The buyer later sued, claiming the seller breached by failing to ship the rice, and the court found that that was incorrect. There was no duty to ship the rice because a condition had not occurred. The shipment of the rice was conditioned on the buyer providing a shipping delivery address by a specified date, and when that condition did not occur, that duty was discharged. It was not possible to provide a shipping address by December 17th at any time after December 17th, and so by operation of Restatement Section 225 sub 2, the seller's duty to ship the rice was discharged. Interestingly, the court also found that the buyer breached by failing to fulfill the condition. It wasn't just a condition of the contract that a delivery address be provided by that date. It was also an affirmative duty by the buyer. The buyer had an obligation to the seller to provide that shipping address and a quantity of rice by December 17th. And in failing to do so, the buyer breached. As a side note, in this case, the seller did not sue the buyer because the price of rice went up and not down. As a result, they did not actually want the buyer to buy the rice. But it still stands for the concept that we have a promissory condition on the seller's obligation. So the seller did not have to ship the rice without getting the delivery date by the specified time. In fact, the failure to receive that delivery date by December 17th discharged the seller of its obligation, and in addition, the buyer had a duty to provide that information, and by failing to do so, the buyer breached. This, therefore, was a promissory condition. Let's return to our friends Abby and Brian in Hypothetical 5. Now let's imagine that Abby is moving to Florida, and in Florida they don't have the same emission standards as where they're coming from. So it doesn't matter to her anymore that the car failed inspection, and she wants to buy it anyway. So even though Brian's car failed the inspection, in other words, even though the condition did not occur, and she has no duty to buy the car because the condition did not occur, can she cause Brian to sell the car to her anyway? Yes, she probably can. This is a concept called Waiver of Conditions, and we find the Restatement Section 84.1 speaks to this. It says, a promise to perform all or part of a conditional duty under an antecedent contract in spite of the non-occurrence of the condition is binding. And it goes on further to say that this is an equitable concept. We're going to need to unpack this a little bit, and then we'll look at J&A Realty Corp., a case that discussed it. First, you should know that waiver of conditions is not unlimited. There are only certain types of conditions which can be waived under this equitable doctrine. When a condition is not incredibly substantive, comparatively minor, procedural, or technical, the promissor's promise to disregard the non-occurrence of the condition is permitted. Why? Well, it does subject the promissor to a new duty, but the duty is not significantly different from the old duty. Without getting into the complexities of how this is a type of contract without consideration, there's no new consideration for the promise, I will leave it at this. Parties are generally free to waive conditions when those conditions are not very material in relationship to the nature of the entire contract. I think an example will actually help make this quite a bit more clear. And keep in mind, this is an equitable doctrine, and so it is very dependent on facts and circumstances. In the case of J&A Realty, a restaurant owner had a long-term lease. The lease contained a provision that allowed the restaurant owner to renew the lease, but in order to do that, the restaurant owner had to provide notice by a certain time. This is sort of like the case in International Rotterdam, where the buyer had to provide a shipping address by a certain time in order for the shipment to be made or for the lease to be renewed. Even though the restaurant owner had no good reason for not renewing the lease on time, it was going to subject that restaurant owner to a lot of hardship. Turns out that it's expensive to design a new restaurant and to move a location. So the court found that the lessor, J&A Realty, had waived the provision, seeing that it was minor in relation to the length of the lease. Again, this was an equitable concept, and it makes sense to read the case in some detail to understand how the court would have come to this conclusion. I think reasonable minds can disagree whether it was the right result, but it does show you the concept of waiver of conditions. There's also a concept of reinstatement after waiver, and a hypothetical will hopefully illustrate that for you as well. In Hypothetical 6, let's imagine that before the parties exchange the money for the car, Abby's move is canceled, and she's stuck in New York, where she lives, and lives with higher emission standards, such that she would need to have the car pass emissions. She once again reinstates her refusal to buy Brian's car because she's no longer moving to Florida. And she states that the car failed inspection and it did not meet a condition. Now, again, she had originally said that the car is subject to a condition. Later, she purported to waive that condition, saying she would buy it anyway. And third, wants to reinstate the condition. She refuses to buy the car. Can Brian sue Abby for failing to buy the car? In other words, is Abby entitled to reinstate the condition? This is another equitable doctrine, and this one's even murkier. The answer is, at best, maybe. The rule comes from the Restatement section 84 sub 2. If such a promise is made before the time for the occurrence of the condition has expired, and the condition is within the control of the promisee or beneficiary, the promisee can make his duty again subject to the condition by notifying the promisee or beneficiary of the intention to do so. Well, as I mentioned, it's an equitable doctrine. You'll have to read a bunch of different cases to get a feel for exactly how this works, but I'll give you one example from Gilbert v. Globe and Rutgers. This dealt with the reinstatement of a condition in a fire insurance policy. The fire insurance policy provided that unless suit is brought on the policy within 12 months after a loss, no recovery can be had. In other words, the fire insurance company's promise to pay for the loss is subject to a condition that suit is brought on the policy within 12 months. A short time later, while Mr. Gilbert still had the ability to bring suit within the necessary time period, the insurance company contacted Mr. Gilbert and told him that he did in fact have to bring suit. Was the insurance company able to reinstate its condition? In this case, it was. In the absence of special circumstances, the parties will be able to reinstate their condition when there's no harm to the other party. Since Mr. Gilbert was still able to bring his suit, the insurance company was able to reinstate its condition that he do so. In addition, the court here found that Mr. Gilbert had 12 months from the reinstatement time, as opposed to the original time. Again, this is an equitable concept, and so the court here found that the equitable remedy was to give the condition back to the insurance company, but to give Mr. Gilbert a little more time to fulfill it. Let's look at one last hypothetical. In this Hypothetical 7, Abby specified to Brian that when he got the inspection, he could only get the car inspected by Carlos. Instead of having the car inspected by Carlos, Brian went to the same shop and instead had it inspected by Deborah, who is an equally competent mechanic. And for those of you who haven't had your car inspected, it's just a matter of getting a sticker on it or not. The car passed inspection, and it would have passed under Carlos and passed under Deborah, but technically, Brian did not comply with Abby's condition that this car be inspected by Carlos. Abby then refuses to buy Brian's car because it had its emissions inspected by a different mechanic. Will a court require her to buy the car anyway, even though the condition was not completely performed? Probably. The court will probably excuse or modify the condition. To look at why, let's read Restatement Section 229. To the extent that the non-occurrence of a condition would cause disproportionate forfeiture, a court may excuse the non-occurrence of that condition unless its occurrence was a material part of the agreed upon exchange. It doesn't seem here that having the car inspected by Carlos as opposed to Deborah was a material part. She just wanted the car to pass emissions so she could drive it. Therefore, a court would be likely to excuse the non-occurrence of that condition where it was not a material part of the exchange. We also can look at Burger King Corp. v. Family Dining for an illustration. Here, there is an excuse of a requirement to open restaurants promptly every year. Family Dining entered into a franchise agreement with Burger King, in which Family Dining had an exclusive right to operate Burger King restaurants in a certain area in Pennsylvania. This promise of exclusivity was subject to a condition, the condition being that Family Dining open a new restaurant every year for 10 years, promptly on the anniversary of the year. For a while, Family Dining did a great job, opening the restaurants right on schedule. They encountered some delays in opening the 4th and 6th restaurants, even though they made their best efforts to get them open on time, and Burger King granted them extensions. The 5th, 7th, and 8th restaurants were open on schedule as well, and then they had further delays with the 9th and the 10th restaurant. Burger King gave them a really hard time about this and wanted to stop providing an exclusivity clause, stop giving them the exclusive territory, claiming that they failed to fulfill the condition. They didn't open the 9th and 10th restaurant on time. After the deadline for opening all 10 restaurants had passed, Burger King warned Family Dining that it was in default. Family Dining opened the last 2 restaurants anyway, despite Burger King's insistence their agreement was terminated. Burger King sued to stop Family Dining from using the Burger King trademarks at this restaurant, which would have been debilitating to the business, and asked the court for a declaratory judgment that the contract was no longer in effect. Although the schedule was an express condition and not a promise, and although this express condition did not occur, the court considered that Family Dining would have disproportionate forfeiture if the contract was no longer in effect. It moreover pointed to the fact that Burger King did not object to the early delays, and that if Family Dining were forced to forfeit the right of exclusivity, it would lose something of incredible value based on its time and investment of money in the area, and the significant risk it assumed in the fact that it had a 80-year exclusivity agreement. And such a loss would be without any commensurate injury to Burger King by the delay. Burger King was barely harmed at all. Therefore, the court, in equity, balanced the interests and determined that it would excuse the condition. There is a lot more to conditions, but I hope this short video at least refreshed your recollection on what you may have learned in class, or gave you a head start in studying further. Let's summarize what we learned. Offers usually propose an exchange of promises, but sometimes those promises are subject to a condition. A condition is something that makes a promise subject to an uncertain future event. Until that condition occurs, the duty to perform the promise is not yet due. At some point, however, the failure of that condition to occur discharges a duty indefinitely. In general, the non-occurrence of a condition is not a breach. Conditions are not generally understood to be promises, but in some unique circumstances, a term can be both a condition and a promise. These are called promissory conditions, and the failure of a promissory condition to occur is a breach. Conditions can usually be waived, especially when they're minor, although this is subject to courts in equity, and waiver can even sometimes be retracted, although that's a little less common. Courts may also excuse conditions to avoid forfeiture. Up next, we're going to look at a very particular kind of a condition, conditions of satisfaction. Special rules apply to conditions of satisfaction, and we'll learn about those special rules in the next lesson. Thanks for joining me to discuss contract interpretation, express conditions.